Recording.
All right, well, welcome everyone back to CS Bars after a little bit of a hiatus after the last meeting. I want to welcome everyone, including some of our new members as well as members of the public. So let me start first with a welcome to our new members. I am very excited that Jessica Park from Abraham Lincoln Law School and Mike Clancy from Northwestern California University School of Law are joining us here as part of CS Bars. So thank you both. They come with vast experience, not just in legal education, but certainly in accreditation as well. So I think there's going to be some wonderful contributions that they're going to be able to make to the work that we do. But last time we were able to welcome Paul Kramer and say goodbye to Kareem Gangora, who was our CBE representative to CS Bars. And so Paul Kramer joined us at our last meeting. Unfortunately, we didn't get a chance to say goodbye to the CS Bars members that had been with us for the last year, Greg Brandis and Brian Patel. I don't know whether they are in the public area or not, but if they are, I just wanted to extend my sincere and heartfelt thanks for the incredible work that they did during that year-long march that we took through the accreditation rules to dismantle them, to rebuild them, and to get them to the CBE. So Greg and Brian both played a really critical role in the work that we did there. And so I want to make sure that it's on the record that CS Bars and I think CBE as well extends their thanks for the work that they did. So thank you to Brian and to Greg. And now I know that we have some other people with us today, and I want to make sure that we're able to recognize them as well. Amy Nunez, who is the director of the Office of Admissions, Audrey Ching, director of Office of Admissions as well, Natalie Leonard, who is always with us and supporting the work that we do as well, and then Grant Wettkesser, who is the program analyst, and I'm sure we're all getting adjusted to having emails come from Grant regarding our work. So I want to welcome everyone to the CS Bars meeting, and now I'd like to make an offer for public comment. We're going to limit public comment to no longer than 3 minutes, and we're going to have you indicate that you want to make public comment by raising your hand, and then the State Bar staff will unmute you and give you an opportunity to make that public comment.
In Gardena, I don't see any hands raised.
Nope.
All right, so we're going to move forward with our discussion today. And as you can see from the CS Bars agenda, we have a rather full slate of information from the State Bar that that is happening, both things that have happened in terms of the bar exam, as well as the bar exam going forward, as well as some other items. So what I plan to do is let's see the length of time it takes to get through the staff agenda, and then maybe take a small break at the end of that staff agenda for about 5 minutes, just to give people an opportunity to get up from their chair, and then resume, and we'll go on with the business of the meeting after that small break. So staff report, Natalie.
Sure. So I'm going to bring up some slides that I think will be helpful, just due to the number of topics that we're going to be covering. And if Amy is ready, we can start with an update on the Provisionally Licensed Lawyers Program implementation.
Okay, thank you, Natalie. And thanks, everyone. One person I think that we didn't recognize here also is Ken Holloway. He is our State Bar staff member from the Office of General Counsel. So
Thank you very
Thanks,
much,
Amy.
Amy. Sorry
No
about
problem.
that, Ken.
That's no problem. I try to stay in the background here.
I can't believe I left the lawyer out of the introductions.
All right, so I want to provide everybody with a background on the provisionally licensed lawyer program. And I'm wondering if if you have the PowerPoint, grant ready to go.
Yeah, are people able to see it?
I think what we see is the drive.
Yeah, so I think you need to unshare, maybe reshare. We see you when you
Here we
clicked on
go.
it.
Okay.
Okay,
There we go.
thank you. Great. All right, so just a little background about the program itself. In July of this year, the California Supreme Court directed the State Bar to develop and implement a temporary supervised provisional licensure program. It's a limited license to practice California law under the supervision of a licensed attorney. The program allows 2020 law school graduates to practice law as provisionally licensed lawyers under the supervision of an attorney. Applicants must meet the most licensing requirements with the exception of the bar passage, MPRE passage, and moral character clearance. And the supervising lawyer must agree to assume professional responsibility over the work of the PLL. The program is scheduled to terminate June 1, 2022, unless extended by the court. And provisionally licensed lawyers will be able to engage in all activities of a fully licensed lawyer, subject to certain restrictions. As for eligibility for who can participate, I mentioned applicants who are 2020 law school graduates, and that is specified as those who graduated between December 2019 and December 2020. You also have to meet the following requirements. Have submitted a moral character application, I should say a complete moral character application. And that's a very big point of clarity. We've received some moral character applications have started, and that does not comply with the requirement. It needs to be a complete moral character application. You have, if you have not passed the MPRE prior to enrollment, then you need to take 4 hours of legal ethics training included in the 10-hour new attorney training within the first month or 30 days of the training being made available. You cannot have any outstanding child support arrears, any unpaid admissions fees, and the applicant must have an employment offer or conditional employment offer, whether that's a paid position or a volunteer opportunity. As for the supervising attorney requirements, the supervising lawyer must have practiced law for at least 4 years in a U.S. jurisdiction and have practiced actively in California for at least 2 years immediately preceding the time of supervision. They must exercise competence in the area of Californian law in which they're supervising the PLL, and also must be in good standing with the State Bar of California. Once it's determined that the supervising lawyer is eligible, some other considerations that supervising lawyer needs to keep in mind is that he or she must work for the same firm for which the PLL is being employed or volunteering at. The supervising lawyer must agree to assume professional responsibility. And there must be a written disclosure via email or other means at the outset that representation of that PLL begins, as a PLL begins to provide legal services, that a participant of the PLL may provide legal services related to a client's matter. So it's a disclosure to that client. A declaration is also required from the supervising attorney that confirms that the applicant will be employed or volunteered at that same firm as a supervising lawyer, that the firm has an office located in California, and that the nature of the employment conforms with the requirements of California Rule of Court 9.49. And lastly, if there are any conditions that change and the PLL is no longer working with this supervising lawyer, the supervisor must notify the State Bar within 10 days. For applicants to the PLL program, the application process happens through the admissions applicant portal, so through the AIM system. Applicants need to register with the Office of Admissions, either as a student applicant or attorney applicant for those attorneys receiving like an LLM around this time prior to applying for the provisional licensing program. Law school graduates need to provide official sealed transcripts, And for those graduates that have been deemed eligible to sit for bar exam, perhaps for the February or for the October exam, we don't need the documents again. The official sealed transcripts that we received as part of the eligibility criteria for that exam is sufficient. Also, applicants must submit a declaration for each supervising lawyer. They must accept the conditions noted in the applicant declaration and pay the corresponding fees. Once applicants are approved, the applicant must complete the State Bar new attorney training program within the first 12 months of provisional licensure. Also, as we do with our licensees, we have also added a place on our public website that allows the public to access and determine whether somebody has been provisionally licensed, as we do with our licensees. So you can go to our admissions website under special admissions, provisionally licensed lawyers, and find our the search engine to look for an applicant who's registered. And you can also use the same search engine to look by supervising attorney. And so the program commenced on November 17th. And some of our statistics, by day one, we received 421 applications, of which 33 were approved that day. As of December 1st, we had 835 applications. This is yesterday, and 387 have been approved. So the program is moving smoothly. There are potential changes to the program that will be discussed by the working group that established the parameters of the program. And there's a meeting that will be scheduled later on this month to discuss two considerations. One is, and these considerations have also been put forth in a proposal that we're going to the court. One is to expand the eligibility criteria and to give consideration to those who have taken the bar exam and scored at least a 1390, which is a new bar exam cut score, to previous examinations, on previous bar examinations. And we would be going back to July 2015. And also the group is looking and proposing that applicants should be permitted admission to the State Bar without having to take another bar exam. And upon successful completion of a certain set of supervised hours under the PLP and under the satisfaction of a evaluation conducted by the supervising lawyer. So those changes are forthcoming and are in discussion, and would probably go to a public comment period before implementation if the court approved. So that's where we're at with PLL. Are there any questions?
Any questions by the committee?
I had two quick questions, if I could.
Yeah, Jay.
One, just on the submission of transcripts. As I understood it, if they were sitting for the bar, they've already been certified, they do not need to send them in. If they have never sat for a bar nor been certified for one, is the student graduate submitting it or is the school submitting it?
If the student can, if they can't submit, if they are sealed, but for the most part, those are usually submitted by the school upon the student's request.
And would that be similar to the certification where our registrar would receive a request from the bar?
The registrar receives a request, should receive a request from the student, unlike the bar exam where it's a collection of everybody who's registered with us.
Okay, perfect. Last question. Do those that are GBX examinees, law office study, judicial chamber study, do they qualify for this?
Yes, they do. As long as they've met the education criteria, then, and that is among them, then yes, they qualify.
Perfect. Thank you.
Sure.
I have a question.
Yes.
I'm curious about whether or not they will be listed on the bar membership pages. You mentioned the list that's available that'll have their names and then also a list with the names of the supervising lawyers. Is that does that involve in any way the regular membership page on the CalBar website?
No, we really tried to keep it simple, you know, and distinguish between those that are licensed and those that are provisionally licensed. And so this, the groups that are provisionally licensed will appear on the admissions portion of the website under provisionally licensed lawyers. And I can show you that if you'd like to see it, just to demonstrate. And just to distinguish that between that and actual licensing. Would you like to see that?
It's not necessary for me.
Okay,
Thanks for the answer to the question.
sure.
Any other questions from members of the committee?
I have one, Jackie.
Yes, Greg.
And perhaps I missed it, but how long does one have to be on the a PLL before becoming fully licensed, and what's the transition? How does that take place?
And this is,
That I missed it. I apologize.
oh, no problem. So right now, the PLL is not a pathway to licensing without the bar exam. That is a proposal right now on the table, and there are a variety of proposals in terms of how much time, distinguishing between those have been taking the bar exam at a later time than those who more recently have taken the bar exam. And the proposals vary from 360 hours to I think down to, I think it's 200. I can't recall at the moment. But all of those that proposal is being discussed with all the parameters around the different times required. So like I mentioned, that's happening this month.
Oh, Amy, I can update that if you want.
Okay, thank you, Paul.
Yeah, we actually had the meeting, and it's been referred to the Board of Trustees to put out for public comment. I think it has to go through them, but anyway, it's going to go out for public comment. Initially, what we did was approve their inclusion in the program back to July 2015, and then at the last minute in that meeting, the proposal to perhaps allow them to skip the bar exam upon satisfactory completion was added, and we had to have another meeting to discuss that, which we did. The recommendation, or what's going out for public comment, are a set of rules which do not differ except in the number of hours, which is what you're asking about. And the lowest number of hours is 360 hours, I believe, for those who passed in July 2017 or sooner. And then if you go back further beyond that to July 2015, I think it was 480 hours on the low end and 600 hours on the high end.
Thank you, Paul. Are there any other questions from members of the committee?
I had two questions,
Yes.
and I will say them very quickly. I had a little bit of freezing, so if it is something that was covered, I'm sure I'll be able to go. So one question I had was just about the trainings. I was noting down throughout the description, and it sounded like there was a new attorney training program within the first 12 months of professional licensure. But I heard earlier on there was also within the first 30 days another training, and that's actually where it froze.
Mhm.
I just want to be sure, it sounds like those are two parallel sets of training required for PLL, and just to get clarity about that first
Okay.
one as a cutout of it.
Oh, sure. So the first one is the 4 hours of training that I talked about are for the legal ethics. This is in the event that somebody has not passed the MPRE or did not receive a passing score of 86 or above on the MPRE. In lieu of that, you could take the 4 hours of the legal ethics from the 10-hour new attorney training within the first 30 days that the training is available. And so that is one set of requirements, and that's in the instance where the MPRE has not been passed. But overall, once somebody's approved and they're in the program, they have to take the 10 hours of training within the first 12 months.
Okay, thank you for that.
Sure.
And then my second quick question is, I just, I think I wrote it down, just the statistics and what was there for December 1st. So there's 835 applications and 387 have been approved. I was just curious, is that a matter of applications to review, or is that a matter of there's some consistent theme of what applicants are missing that's coming up?
Yeah, so it's a couple of things. We don't have a high denial rate. Those that have been denied so far, for the most part, people who are perhaps prematurely applying that are not graduates of the 2020 or more recent graduates.
So
And
they don't meet criteria.
yeah,
Mhm.
so it's an eligibility criteria issue. We also have some that have been submitted or drafted but are not finalized. Like there's a step that's missing, either perhaps the payment or some of the documentation. And so it's a combination of items.
Thank you. And Amy,
Thank
just a quick question about monitoring this program, because I think it's an exciting development for the state bar in terms of thinking holistically about how to license new attorneys and provide mentorship and make sure that they're kind of being brought into the profession in a way that we hope leads to competency and especially ethical behavior. I'm wondering what kind of data collection or other things the state bar is doing in order to kind of think about this program as potentially something long-term for licensing in the state.
We worked significantly to create an automated system in our current information management system. And through that, we're able to collect a lot of information in terms of, the eligibility criteria and linked to somebody, to everyone's application process. But along with the proposed rule changes is also the requirement that applicants complete get an evaluation from the supervising lawyer, as well as a log of their hours. And so we will have quite a bit of data tied that can serve as an evaluation for that purpose in the future.
And if I'm a client, can I file a claim, a disciplinary claim against the person in PLL and or the supervising attorney? I'm just wondering if there are issues of competence or other things related to ethical lapses, will that be collected directly against the PLL or against the supervising attorney, or both?
Both. They are both held as a licensee is, and are obligated to meet those rules and face the same type of violation processing as licensees.
Okay, thank you, Amy.
Sure.
All right. So the wonderful update. I'm excited to see how this kind of moves forward and how our graduates doing it. I know our graduates were very excited to have this opportunity presented to them. So I want to thank the CBE and the State Bar staff and the Supreme Court for their efforts to put this program together. I think it's a really exciting development. And so it looks like we're moving forward. Natalie, I wasn't sure whether we skipped over the rules piece to hold it off till later. Are we moving forward with the first-year law students exam or going back to the rules provision?
I already mentioned the rules provision, so I think we're ready for the first year exam.
Oh, okay.
Yeah, sorry about that.
It looks like my slide is blank and probably looking for where my notes are, but I can also go ahead and speak about it without the notes. On my version, I have some notes, so I'll, which is fine. So we just, for the second time, gave a remote version of the first year law students exam. We had 309 take the exam online, which was more than what we had in June. 7 were in person at either our San Francisco or Los Angeles office. Not just folks with testing accommodations, but a couple who indicated they had extenuating circumstances and wanted to come in person because what they had at home wasn't going to be sufficient for the remote exam. So compared to the first remote first year law students exam in June, and really our first all remote exam at all, there were virtually no support calls. So it was a much better experience, I believe, for all the test takers, and a better experience on our part for not worrying that we had miscommunicated with test takers. So we had virtually no support calls. The experience was relatively seamless. The passwords, we've learned a lot about passwords in the past several months. We posted them on 2 different websites, and we also emailed them. So we had a lot of backup as well for how we got information out to folks. And I think that it really showed in how, as soon as the passwords were released, and they had 25 minutes after that time to get into the exam. As soon as they were released, 75% of test takers just started going for it early. So everyone kind of knew the drill this time around, which was great. And results for this exam are due to be released on February 26th. So let me know if you have any questions. Oh, there they are. I did it. That's everything I just said.
Okay. Any questions from the committee? Okay. All right. And it looks, Audrey, that you're doing the next one as well.
Actually, Amy's going to pick up on this slide, but I'll probably interrupt her at some point.
Okay.
All right, perfect, thank you. So where are my notes? Here we go. All right, so in June, when we conducted our first online exam with the first year law student exam, we developed a post-exam survey for examinees who sat for that exam. And we used that exam, the post-exam survey, to model the one that we conducted for the October 2020 California bar exam. So we worked with the National Conference of Bar Examiners to design a survey that would elicit information about a range of topics that include familiarity with the exam taker with online examination, the steps that they took to prepare for the exam, their assessment of the utility of the instruction materials developed to assist with the exam, concerns about the remote administration and challenges that they experience with specific components of the remote exam, such as technology, location, the utility of the mock exam, and the response of the help desk or support. And the goal was to gather as much information as a means of improving the remote testing experience for future exams. So all in all, the survey was sent to 9,615 examinees, were all the examinees that registered for the remote exam. And we heard back from more than half, 5,305, which yielded a 55% response rate. And we learned a lot in the process. Among the items, it's clear that test takers were under extraordinary stress for this administration of the exam. The pressure of the pandemic and the short timeline available to adjust and prepare for the remote administration was reflected in the number of the survey, in a number of the survey results. So to begin with, almost 6 of 10, so 59% of respondents expressed moderate or extreme concern over having to take an exam in any manner during the pandemic. However, despite this anxiety, when asked how they would prefer to take the bar exam if they had to sit for it again, respondents reported as follows, and that's what you have, I think, before you, right? Yes. About 2/3, so 63 reported preferring to take it online in an isolated environment like at home or in a hotel. Another 25% preferred to take it on a computer in a group setting, such as at a school or at a test center, while only 6% reported a preference for taking the exam in some other fashion other than a computer, so for perhaps in person. Over half of the respondents, 57% reported that they were satisfied with remote testing. 28% reported some level of dissatisfaction. What we wanted to also gauge, can we go to the next screen, please? Is the technical experiences. So as for technical experiences on the day of the exam, about 1 in 5 respondents, 22%, reported having technical issues with the mock exam. And of those, more than half, 54%, reported that it took them more than 45 minutes to resolve that technical issue during the bar exam. And the mock exam was very significant. It was a significant part of the remote testing process. The mock exam, the idea was that it would mimic the actual bar exam by allowing the same features that were at the bar, that were going to be available for the bar exam during the bar exam, and the same challenges, accessing the password, implementing and inputting the password, looking at the testing formats, whether it was an essay, PT, or multiple choice. So the idea was if somebody was successful in the mock exam, it would lead to greater success for the bar exam. And that could have been what happened also, because on the actual day of the exam, we had only 15% of respondents reported having a problem. More obviously had reported problems during the mock exam. ExamSoft also conducted analysis of information, and they indicated that they were contacted by just 8% of exam takers on exam day, and the company was able to successfully resolve over 80% of the inquiries they received that day. So as I mentioned, the idea of using this data was for us to look at methods for improving the exam for future administrations. And there are 3 areas that we're going to focus on. One is the instruction material. That is all of the information that's going to be shared with applicants in this process, from the testing conditions. We're using FAQs and refining those and updating them as much as possible throughout this exam cycle. The timeliness of instructions, we had a very short time frame from the point that we knew we were going to do this as an online exam till exam day. We've already started our FAQs and the testing conditions information sharing to help address some of the timeliness issues. And we're also working hard with ExamSoft to ensure that the features that they have available for the bar exam will also be available for the mock exam. And so we're putting a lot of efforts in those components. The other thing to note is that we have a lot of data that we collected with our post-exam survey. So we're in the process of developing a summary of findings that will be placed on our website. So you can take a look at the various areas with more detail as to what we collected in the post-exam survey.
Thank you, Amy. Are there any questions related to that piece of the update? Yes, Greg.
Amy, do you know what the coefficient of reliability was on the exam for which you have results?
On the post-exam survey?
No, on the exam itself.
No, we are still in our grading process.
Okay, thank you.
Sure.
Other questions from the committee?
I don't have a question, but I had an observation. It seems to me from what I've heard that there were 0 support calls related to the October first year exam, but then for the general bar exam, there were reports to ExamSoft. What was it, 8% of the 15% who had technical problems contacted ExamSoft. So it sounds like there's a difference with technical issues comparing the first year exam to the general bar exam. Is that observation correct?
It is, and I think it could be part of what contributes to this is the fact that this is going to be the second time the October first year exam is the second online exam that happens for the first year exam. Sorry, let me explain that. The October exam is the second online version of the first year exam. Well, this is the first time in November. I'm sorry, I'm mixing November and October. Let me start all over again. Sorry about that. So the November first year exam was the second online exam that we've had that is the first year exam online. The October exam that we conducted, which was really the July bar exam, was the first time that we went online. So I think part of it is the familiarity that people had with a remote testing experience.
That makes sense. Thank you.
Sure. Sorry about the word blender there.
Well, I understood all along. Thank you.
I didn't.
Yeah, and Amy, a quick question. I think after the first year law students exam, in the meeting, you identified kind of the number of flags that showed up when the proctors as well as the State Bar did a review. Do you have the numbers of flags that came up during the bar exam as well? And more those that resulted in potential disciplinary concerns on the part of the bar?
Yeah, that's a great question, Jackie. And the issues that we don't have that because we're in the middle of the review right now. It is something that we will be gathering, and it sounds like the deans are interested in this, and so hopefully we'll have them by our next meeting.
Yeah, that's great. And I'm hoping that we'll even have more interesting questions about or more familiarity with ExamSoft remote proctoring as graduates come through, since it's been, I think, more of the norm for many law schools in the pandemic. So I think hopefully those technical issues as it relates to user error or confusion will reduce with time as well.
Exactly.
Okay.
I also have a question. Regarding remote proctoring, do we have any data yet on how many initial sort of flags there were and how many has that filtered out to in terms of actual violations? Do we have any data on that?
No, that's what we're saying that I just mentioned. We are in the in the middle of the review process, or maybe 3/4 of the way through. So we have not completed all of the review yet. And we're hoping to have those statistics perhaps by the next CS Bars meeting.
Okay.
Okay. All right. Okay. Thank you, Amy.
Sure.
Next up on our agenda.
Deadlines.
I think it's me again. Yeah. So right on the
All right.
heels of evaluating the October exam, we're ready to go with the February exam. We actually opened applications on October 1st. So the applications for this exam were open even before we administered it because of all the postponements, the October exam. So as of yesterday, we have 2,121 applicants for this exam. On November 19th, the Supreme Court did direct that we were going to administer this exam remotely. Of course, like the October version, we will have in-person sites for those with extenuating circumstances or those needing accommodations. But we're looking for the bulk of applicants to be testing remotely again. So these deadlines are all posted. You don't need to take any notes, but these are all posted on our website. The final filing deadline of January 4th. There's a series of different dates for when folks can withdraw for different percentages of refunds. Obviously, it's better to be in the band where you get some refund than no refund. So hopefully applicants are taking note of that. So not only do immediate repeaters have 10 business days after the release of October bar exam results to timely file, we are also opening up applications on January 2nd for folks who did take the October exam, even though that's ahead of when the results will be released. So we've had, feedback from applicants that really would like to apply even before they know whether or not they have passed, either a feeling they have about how they might have performed, or they just want to apply ahead of results. So that will be open on January 2nd. And if they find out when we release results that they passed, they will get a refund. Natalie? So the final filing deadline, January 4th. All the different testing accommodation deadlines, you're all familiar with sort of this cadence, since this is similar to what we do every exam in terms of when they can file or when they can file appeals and when you can file emergency petitions. We also, today, hopefully, or tomorrow, working with IT to send this out. So what we learned, as you saw from the post-exam, we learned that timeliness is so helpful for applicants and for deans, right? So we're going to send out the acknowledgement and acceptance of testing conditions document today or tomorrow to everyone in that pool who've already applied. And then as people continue to apply, continue to send out to them far in advance what the testing conditions are. Now we know we're having a remote exam. This is what your expectations of conduct are. And this is what you need to have in terms of the, conditions of your, Wi-Fi and your working microphone, working camera, all the conditions will be going out a lot earlier, and they're not due until January 15th. We've also updated the February bar exam FAQs are already posted. The exam schedule is posted. And then a PDF of those conditions are part of the FAQ. So if folks want to read them even ahead of time, they can read what they're going to be agreeing to. So yeah, lots of lessons learned. And then please encourage everyone, to whitelist emails from us and to check the spam and junk mail folders. We've done a much better job of posting not just statutory deadlines, but all of these deadlines. If you go to the next page, you can see some of these deadlines about mock exams, about those testing conditions. Those weren't necessarily posted on our deadlines page because I think our mindset a lot was like, what are our statutory deadlines? But now we're posting all the deadlines so applicants know far in advance when their expectations are going to be to do those mock exams, to download their file so they can actually take the exam. All of those deadlines are already posted far in advance. Again, lots of lessons learned. I know a lot of you received emails from me when we were emailing the applicants. We're going to start with those weekly emails again in January. I'll be sure to send copies to all the deans again about what the communications are for applicants, so everyone's on the same page. Answer files and video files are always due to be uploaded by standard applicants the day after the exam, so February 25th by noon, and then depending on extra time or extra days, you get extra days to upload that as well. So we've also, after the exam was administered, there were a lot of emails that came into the bar about a variety of questions about your uploading of video proctoring files, or, what if a dog barked in the yard next to me? Did you hear that? Whatever it might have been. So I'm also going to work with the team to post some post-exam FAQs. So hopefully that'll help. And again, we are ever learning during this process to make things more clear for you if you get questions for the deans, and then obviously for the applicants. So just some of the thoughts about February. Any questions?
Thank you, Audrey. Yeah, any questions from the committee?
This is,
Jessica?
yeah, thank you. This is Dean Park. First of all, before I ask my follow-up question, I just want to send a lot of appreciation to Audrey. I've been seeing your emails to the deans, and I can't tell you that during a year with a lot of moving timeframes and targets, how helpful that is. I think our students, sometimes they need the reinforcement from us, especially as things are shifting. And so I appreciate that, and I definitely heartily support that continuing in the future so that we can know what links to direct them to or reinforce. I know I sent a couple of reminder emails as well generated from that. So it's very helpful during this stage. I wanted to have that follow-up question, just going back to that sentence about immediate repeaters having the 10 days. And I think you mentioned the release then date, right? Was it
Yes.
January 2nd?
Oh, no. So sorry if I was confusing. So we're opening up applications for those October takers on January 2nd, even though that is before the scheduled release. So the scheduled release of results is mid-January. That's what we've published. We've also published that we're trying to expedite that. So our grading team is trying to release results earlier than that. Obviously, it behooves all those applicants to know ahead of time if they've passed. So we're trying very hard to release it earlier. Regardless, they'll be able to apply January 2nd.
Got it. And for those immediate repeaters, they get 10 days from the time they really receive their results. Okay.
Yes, right.
Thank
And that is a statutory thing. But yes, they will have that same amount of time to apply.
Great. Thank you.
Any other questions for Audrey on the February bar exam? And Audrey, I too want to extend my thanks. I think you have done, I think we're all learning through this, and the adjustments that you made both in preparation for the October bar as well as shifting to the February bar is that kind of continuous improvement that we always hope that the schools are working towards and our students are working towards as well. So well done on that. Just a question regarding, and I know, are you communicating with ExamSoft or anyone else about computer updates? Because I know the panic that always ensues is, oh my God, my Mac update, my Windows update, and or exam update is happening right before the exam. And that certainly happened right before the October exam as well. And that usually sends students into a panic. So just wondering if is there anyone kind of able to communicate about that piece for those sitting for the exam?
So I'm glad you mentioned that, because it's on those testing conditions. There's a PDF of that on the FAQs. It's going out to the students who've already applied, hopefully tonight or tomorrow. And there are some changes for those requirements that ExamSoft has let us know, because Apple has their own chip processor now, and that's a new update, and that's not something that's compatible with ExamSoft. So we updated that on all our pages too. It's the holidays. Someone might be getting a new Mac computer for the December holiday period that they then would not be able to use for the bar exam. So we're trying to communicate that that you're not going to, those brand new Macs are not going to be compatible with the software for the bar exam. So that's in the requirements. If we need to make that more clear, when you check it out, let me know. We can be as clear about it as possible. But that is something that they were not prepared to support on the ExamSoft side.
Any other questions for Audrey? All right, thank you, Audrey.
Thanks, everyone. Look forward to more emails from me.
Are you ready for recent developments?
Yes, recent developments would be great. Thank you.
Okay, so we have just a few recent developments to share. The first one relates to Bar Exam Strategies and Stories program. This is a program that the State Bar has offered for the last several summer July bar exams and most recently October bar exam. What's recent here is that it's going to be made available for the February bar exam as well for the first time. So this is a program that helps students to have a productive mindset while they are studying for the bar. It's a short program that they can usually complete in under an hour, and it's best completed as soon as they can get to it in their bar study. Applicants can sign up during the registration process, or if they haven't decided to do so when they applied to take the bar exam, they will be receiving a series of email invitations. This program is free, and the first invitation for the February bar exam was sent out to those students who had already applied for the bar exam, and it was sent out on the 25th of November. If they haven't signed up when they're signing up for the bar exam, they must sign up through this link that they get to an email. There's not, for example, a site or the portal they can go to once they have registered for the exam. Clicking through the link in their email will take them to the registration process. And an important deadline to think about here is December 7th. For any of the applicants who sign up by December 7th, they will be included in the first wave of the program. They'll get their materials later on in December, and they'll be able to use them right away. If they sign up after the 7th of December, they will still be able to participate up to the program deadline, but they will get their materials in January. So we wanted to make sure that people knew. Often they might think that this is not something they can access in February, but this time they can, and there is no cost to them. Does anybody have any questions about this program?
Okay, thank you. And Natalie, before you move forward, I need to circle back to something, because I recognize that Marty is actually going to need to leave the meeting, and I failed to both do, in my excitement to get to updates, I failed to do roll call and failed to actually have us look at and approve the minutes if appropriate. So if you wouldn't mind hitting pause on your developments and allowing us to do those two things before Marty has to exit, and then we can move back to the development. So I apologize for skipping over that part of the beginning of the meeting. So thank you, Natalie. Sorry to interrupt. I realize that we are hitting the bewitching hour for Marty. So
Let me take a roll call real quick. How
Yes,
about-
thank you, Grant.
Sure. Chair Jackie Gardina,
Here.
Michael Clancy,
Here.
Jay Frickberg,
Present.
Paul Kramer,
Here.
Greg Murphy,
Here.
Jessica Park,
Here.
and Martin Pritikin.
Here.
All right. Did I miss anyone? I don't think so.
Thank you, Grant. And now Grant also distributed the minutes. There was a problem with the link on the website, so he contributed it or distributed it to us individually. I'm assuming, and I just want to confirm that that link will be fixed so that the public would be able to see it at a future date. So I just want the minutes been distributed to everyone. Are there any corrections to the minutes? Okay, I just want to make one typo correction in that first paragraph. You have a double meeting in there, bar examiners meeting. It sometimes feels that long, but there was just the one meeting. So just, I think, cross that out. Any other corrections? Okay. So assuming those corrections are made and everyone agrees with those corrections, then we can approve the meeting, the minutes as distributed. So
Approval.
do we have a second?
I second.
Okay. Grant, will you do a verbal roll call vote? And
Yes.
obviously our new members weren't there for the meeting as participants.
Sure. So Jackie Gardina,
Approve.
Jay Frickberg,
Aye.
Michael Clancy was here. No. Okay. Sorry. Paul Kramer,
Approve.
Greg Murphy,
Aye.
and Martin Pritikin.
Aye.
All right, the motion passes.
Thank you, Grant. And so I appreciate everyone moving backwards for that, and Natalie, for you hitting pause on your recent development. So please continue. Thank you. In the second half. So thank you.
We're recording.
All right, welcome back, everyone, to the business portion of the CS Bars meeting. And it's a fairly full one with some discussion items. And so Natalie, do you want to get us started?
Sure. Okay, so we have a couple of topics, and the first of these is really just an opportunity to give some feedback to the committee in advance of thinking about a future proposal. So this year, as you know, is a most unusual year. And as part of that year, tentatively in March and more affirmatively in June, the committee granted a blanket waiver to all of the schools, something unique that hadn't really been needed in the past. And that waiver allowed all of the fixed facility schools to transition immediately to online teaching as a result of the pandemic. The requirement of the school was that each school had to forward a quarterly progress letter. We received letters in August. We received them again along with the annual reports in November. And this waiver will continue through the end of the school year. So now that we are about halfway through the school year, it seemed like a good time to get some feedback from the schools about how things are working, what the successes are, and what you would like the committee to know about in thinking about your planning for the future, whether collective or individual. And I will say from our side, without identifying any particular school, the schools have been very responsive about sending in the reports. They experimented a little bit at the beginning, in particular with exam solutions, exam delivery solutions, with which we can certainly relate, and also a number of different testing vehicles. But overall, the experience has been very positive. Many schools have reported improved attendance overall, and they are experimenting with options in some cases that they had not considered for their students. So it'd be helpful to hear some feedback from the various committee members here on what's been going on at your schools. Whether you are using the waiver or your school is generally an online delivery type of school.
Thank you, Natalie. So members of the committee that want to speak to this?
And in particular, I'd be interested to know for those schools that normally teach in a distance format, does it feel like in some sense a business as usual year because you have always been able to deliver your program fully online?
Natalie, as to our school, the last part of what you said is true. It's a business as usual for us. The only difference is the proctoring. Prior to the COVID-19 pandemic, we had proctoring that occurred in person. Now we're using vendors for that purpose, examity.com at the moment for that. But otherwise, everything is as it has been.
Mm-hmm. Okay.
I want to report similarly for the Abraham Lincoln University School of Law. So we've been seeing our students or faculty affected by COVID-19 through their work or their family care situations. And our management has a working group that collects data from our student services so that we can be aware of just the number of so our students are impacted. However, when it comes to our orientation or our running of the courses, it is all business as usual. Like Dean Clancy said, the only effect has really been through exam administration. So although it may sound surprising, we too have been pushing more towards online remote proctoring solutions this year, just so students can feel safe when they're taking their exams.
Mm-hmm. Mm-hmm.
Jay.
Yay, yes.
At least for UWLA, I would say that March, when this started, again, with the acquiescence of the committee, it was a revolutionary process for us. We've been an institution since '66, brick and mortar, on campus. Some of our adjuncts have taught 30 plus years in the same classrooms. And so it was revolutionary at that time. And I think since March, it became more of an evolutionary process, at least internally. And the surprise aspect to me in our institution is the focus not so much on the pedagogy and the examination, but the social welfare, the equity interests of our students, as we're all suffering from mental health issues just being in the society right now with COVID-19. And we've tried to come to terms with them on that through extensive, almost census surveys of our students, of our faculty, and trying to find how can we meet them in a very compassionate, but again, still fair approach, similar to what the bar, I think, has been going through. I don't think we could ever envision having a bar exam online. And now we've had 3. So I think that revolutionary, then evolutionary process is what we've been focused on.
Okay. Thanks, Jay. And Natalie, I can add, like Jessica and Jay, I think regardless of our online program, our blended program, or our campus program, the faculty, students, and staff are all being affected in one way or another, some of them dramatically, some of them more in an inconvenienced way, just like we all are. And so trying to kind of create a learning environment which so many people are being affected by the same event, but being affected differently. And I think it's not just the pandemic, but the civil unrest that occurred really had an effect on our students, changed some dynamics in classrooms, changed the way that some faculty started to talk about the law and their experience with it. So I don't want to limit what's happening this year to just the pandemic, because I think everything that's happening in 2020, it's been a kind of a crucible of sorts, and all of that has had an effect. And I know in the spring, we took that kind of a lesson of the pandemic and we recognized the impact it was having, and we changed our grading and we changed our exam format as a reflection of that. as the pandemic wore on, and even though the civil unrest and all of that came with it occurred, we reverted back to our traditional exam format, our traditional grading format. But I can see that students' grades are a little bit lower than normal, I think, or students who were being successful struggled a little bit more in the remote environment. I know students who might have be easily distracted, and so self-accommodated in the classroom, in the brick and mortar classroom, by sitting in the front of the class, or somehow creating accommodations that allowed them to focus on the professor and the classroom discussion more, struggled in the remote environment. We all know that as you sit on Zoom, you can also be on any other number of devices, et cetera. And so that, I think, has had an effect as well. So students with learning differences, I think, are being affected differently, and trying to get a handle on that, I think, takes a while for them. And it doesn't show up for us until maybe a grade comes down. So I think that has certainly been on our mind at our school. One of the ways that we keep track of that is certainly the attendance. But one of the other things we did, because on our campus program, we don't get to see students kind of come in for class and we get a touch base with them then, the student services team is actually doing regular phone calls. So every student gets a phone call at least every 10 days to 2 weeks, where we get a check-in. And some students get texts if that's what they prefer, but it allows us to get have a touch point with them, to check in with them, to find out how they're being affected, and also to get direct feedback on the work that we're doing, both in the classroom and outside the classroom. I think another thing that's happened, like Jay commented, for our campus program, it was a dramatic shift for our faculty, especially. So one of the things, not only were we able to upgrade all our technology in the classroom and for all of our students, but it also, I think, accelerated conversations about teaching and learning. Because the faculty were in a new environment, it wasn't just walking into the classroom like they may have done 3, 4, 5, 30 years in a row. They are being forced to do it differently. And like all of us, when we're forced to do something differently, we start to think differently, or we ask for help, or we engage in conversations. So in that way, it has been a wonderful, I think, door opening to conversations about effective teaching and learning, conversations about collaboration, conversations about assessment, and how to do it differently and better in this environment. So I think in many ways, what's happened during this time will continue. Even if the CBE doesn't necessarily shift what it's doing, I think much of what we've learned and during this process will continue in the schools. I can say, and I don't know what this translates into in terms of a rule or a guideline. And I don't know if it's around attendance or kind of how we define distance technology. Many of our campus students chose the campus program because they wanted to be on campus, or they wanted the synchronous faculty engagement versus the asynchronous experience. And so they missed that, but they don't mind experiencing it synchronously in a Zoom environment. They like being able to go home and have dinner with their families, rather than fight traffic to get to campus. They like not having to leave campus and travel anywhere from an hour to an hour and a half to get home after a class, and not get home until 10:30 or 11 at night. So there's a portion of our students who are actually thriving both personally and academically in this environment. And I think if given the opportunity, they would still choose the campus program. They would still choose the synchronous program, but they wouldn't mind being able to participate synchronously from their homes rather than coming to campus. While some students would say, you cannot open the campus soon enough for me, some students are quite content to be in their home office participating via Zoom. So that's one takeaway, that I think as we shift back to the traditional program under the rules and guidelines as written, some of our students, I think, will struggle with a little bit. That was a very long explanation about what's happening at our school, but I don't know whether Mike or Jessica or Jay have any reactions or anything resonated with them that they think they'd like to follow up on.
I have one comment, and that is that those who enjoy very much going to class probably like the social interaction very much. And I think that doing it in an online setting for those people would be it'd be a loss, and one that they wouldn't be able to handle very well. So I'm guessing that many of those who you talked about who are anxious to get back on campus are of that type, those who really enjoy the social interaction. And I know from having grandchildren who are now involved in remote class sessions, it's a big problem for them. The loss of the social interaction, physical social interaction is problematic for sure. But for adults, for the most part, though, I think they are, at least for those who are in our program, they're able to get by well without that, and they create social interaction online that is almost a substitute for what would happen in person on campus.
Mm-hmm.
I know I spoke already, so I'm open for others speaking in, but want to make sure to leave that space, but happy to respond back if, well, so I did want to just respond back that I just absolutely agree with your point that there's some students that really embrace how the online component, online and synchronous, lets them juggle other things in their life. And some people thrive with that, but there's others that like that artificial, in a sense, compartmentalizing, right? Where you know you have that space not to be distracted. And I'm sure people could see that even from the bar exam administration, where people could be struggling with that. So I did want to note one change we did have to do in our program, even though it usually has an optional live component, is we have a trial techniques class that's synchronous. And so there's sessions every weekend that the students are getting into teams, plaintiff and defendant teams, and working with a very established legal practitioner in the Los Angeles community to hold a mock trial at the end of that 6-week run. Besides other issues of watching out for health and safety, we could not run that course as normal this year, even though that we only offered, that optional on-site component, both for the comfort zone of the faculty member and for the students. That couldn't transition with that much short notice online, with it really being an equivalent experience. So there are things and adjustments that still occur. It doesn't mean it's impossible, but it's still even going to take a replanning of that curriculum to make it as to have the same experience that it was planned with before. So.
And one thing I wonder, based on some of the comments that are coming in, is whether returning to how things were is really returning to how things are going to be. And if there will be a blend that people had not considered before. And I think that the rules proposal is prescient in allowing that new, any sort of new blend, many sorts of new blends that may come forward. The registered schools have somewhat more constraints through the statutory requirements, but we're interested to see if the schools will be reimagining what going back to a fixed facility program looks like, consistent with these comments. Mm-hmm.
Yeah, just to bounce back on Jackie's comments, I can give a couple anecdotal examples. I've been teaching during this whole time period myself, and those equity, quality of life interests, some have improved. As most of us know, going through the law school environment, it's almost of a calling, especially for those that are opportunity mission, where our students are working during the day. Then they come to us at night, and they're literally up from 6 in the morning to usually midnight every day for 3 to 4 years. So I saw a quality improvement in their life when we adjusted our breaks to be in the middle of a class 3-hour session. All of ours were synchronous, and give them 22 minutes. Then they can actually time, if we made our break at the exact same moment every time, they could time their meals to be with their family, with the people they care about every day, when they could not do that normally on campus. I would also say I was surprised that I saw some pedagogical improvements in this process. We were using Zoom as our synchronous modality, and we've started to use the polling feature. So we can create a series of prearranged polling questions. And we would do this normally, I think everyone in class, raise your hand if you think it's A, raise your hand if you think it's B, that type of thing. But the advantage I found in this synchronous Zoom modality is more would take part because it was anonymous. They could vote without having to really risk some perceived embarrassment on their part. So there was more involvement when I thought there might be less involvement. So that was a great improvement from this. And to Natalie's question, I don't think any of us are ever going back to the way it was. I think if anything, the hybrid modality will be the future, where we give everyone a choice, based on their medical conditions, their life conditions. I think that will be the future of education, not just us, but the future of education, period.
Mhm. And so part of what the committee is thinking about is whether a coordinated blanket type of continuation is needed, or whether schools will start to hew their own path and then request permission for what they see. Of course, this is tempered by what's going on in a public health setting, and we hope to keep the dialogue going to understand what the schools and the students are needing in this context. Mm-hmm. So I'll package up the feedback that I've seen here, and I would like to do a little bit more outreach to all of the schools in general, so that the schools can get a better idea of what will be to come in 2021 after the August expiration period of this waiver. Okay, great.
I had a quick question. I know that a topic here is discussion of topics for law school assembly. I imagine that this would be, if there's a survey or if there's a topic, agenda topic, this would be one of those. So just wanted to note it, knowing that we're going to get there.
Thank you. Okay. Dean Gardina, anything else on this topic before we proceed to the next?
No, I think it's important we start to move through this. Apologize for the length of that.
Okay. Okay, so if we're ready, the next thing is to go on to discussing the accredited rules proposal. And I'll start by giving an update on the Board of Trustees action in relation to the rules so far. And then we can talk about the guidelines that may be needed to help operationalize any rule set that is passed. So since the CS bars last met, the CBE got together and discussed and agreed upon a proposal to be sent to the Board of Trustees. They considered the proposal in November at their November 19th meeting and authorized the posting of the rules for a public comment period. Those rules are going to be posted and available by next week for a 60-day period. You see the little blue link here because there is a public comment page on the website. You may not have seen this page in the past, but anytime that there is a rule change, it is posted here. It's a Board of Trustees posting rather than a committee posting, and the feedback can be received through this page. And then after that 60-day period, it'll return to the Board of Trustees for further consideration, possibly adoption or possibly further revision, depending on the public comment. And I'm not sure if people have seen that posting page before, but it is simply just available on the website. It will have not only that proposal, but anything else that is out for public comment at that time. And it explains how you can submit the public comment, and we'll have a link to the forum as well. So that's just a little background of where we are in the rules proposal to date. And so we find ourselves in a point where we are in some sense waiting as the Board of Trustees gathers more information and decides about what to do. And this may be a productive time to start thinking about guidelines that may or may not be necessary. Some of you know the large document, over 50 pages of guidelines related to the accredited law school rules today. But going forward, the thought is that based on the design work that was done here, that a similar document may not be needed. And I put up some ground rules about guidelines in general, that the guidelines are there to interpret the rules rather than to create additional requirements. They may be prescriptive. They may provide a safe harbor offering guidance as to a way that a rule can be fulfilled, or they may not even be needed when a rule is clear on its face. And I'd like to just ask Chair Gardina if she has any other information that she would like to share, just thinking about guidelines in general or ground rules for guidelines.
I think that's a good start. I think one of the things that would be helpful, it's mentioned in the draft rules, but one of the things I'd like to put on the table for discussion, either as part of the guidelines or something else, is a defined process for the development of guidelines as between CS BAR's engagement with State Bar staff and CBE. Certainly there was a process in place with the Rules Advisory Committee. We had a defined process recommended as part of CS BARS, but ultimately not adopted when CS BARS was created. So I think having something that's defined, I think will be a great asset as not just we develop these guidelines, but as guidelines may need to be developed through time as the rules are better understood and as they start to play out in the real world. So I'd like to see not just what the guidelines are going to contain, but also how they will be developed and the process that we'll use in order to engage stakeholders.
Mm-hmm. Okay, thank you. I had some slides to talk about some of the sections to think about specifically, but I don't know if you want to talk a little bit more about process at this time, or that will be something we can agendize for an upcoming meeting.
I'd like to agendize it because I think it'd be helpful to have all of the CS BARS members here, and unfortunately Marty isn't here right now. So it will give people an opportunity to engage in that discussion more fully at another time. And so we'll plan for that ahead. And certainly welcome other members of the committee to contribute to not just the process issue, but any other ground rules for guidelines as initially identified here, but are there other things we need to be thinking about in terms of creating parameters around the guideline development?
Mm-hmm. Mm-hmm. I think that makes please.
A question then, or a comment. Jackie, when do you and others, when do you envision the new rules taking effect? And I ask because I'm trying to plan with the process and the timing of it all with Natalie. It seems like it might be problematic to have the rules take effect before the guidelines are ready. But if that process drags out a long time, you won't be benefited from the new things that you're getting in those rules. And so I wonder what your thoughts are about that.
Thank you, Paul, for that. It wasn't clear to me from the Board of Trustees meeting what, as much as I'd like to think that we had any control over the timing of those, it seems like the Board of Trustees might be defining that process or that timing a little bit more than we may have control. I think we initially put in place 6 months after the, if I'm remembering correctly, after they've been finally approved. So was that still in play before the Board of Trustees? Is that still the thought, or July 1st was kind of the thought based on a backwards calendar look?
Oh, I can take that. So July 1st was proposed as an example, getting back to the 6-month lead time that you mentioned. So if things were to sail through without public comment, that might be a potential suggestion. But of course, depending on the public comment and the Board of Trustees discussion, that could be modified. Mm-hmm. And I don't think a faster timeline was considered in any way, but recognizing that a timeline might need to be adjusted depending on how much further discussion is needed makes sense. And there just might be certain times of year that make more sense, a summertime or a January 1st for the schools.
Thanks, Natalie. So Paul, given that obviously the guidelines don't need to go before the Board of Trustees, it's just a matter of having the CBE approve any guideline changes. It seems as if we were able to rewrite the accreditation rules in a period of time and get them to the CBE by the August meeting, obviously considered in the October meeting based on the need to fully vet that, which I appreciated. It seems one question I would have is we tried to create the guidelines as specific as possible, leaving room, of course, for some innovation and ability for schools to operate within them, but still meet the rules, with the idea that there wouldn't need to be a lot of guidelines created, and that as interpretations or ambiguities came to light, guidelines would be developed to respond to that. It sounds like to me that you might have identified areas that you think there's an immediate need for guidelines. And so the first question would be, what are those? Can we prioritize them? And then we can deal with ambiguities that arise at a different time.
Yeah, well, I'm certainly sympathetic to less is more in this case, and not in favor of guidelines. It's simply summarize what the rules say and attempt to be a one-stop shop for all the information you need as a school. So I think I'm glad to hear we're on the same wavelength there, that we'll add what needs to be added and force people to read the two together in order to learn what their limits are. Yeah, I don't care how long it takes. I'm not to say that I want to drag it out, but I do think it would be useful to have them. I think we have a provision, I think we took out the provision that was suggesting that the old guidelines could somehow be a safe harbor, if I recall correctly, and kind of with the mind that the new guidelines will be ready by the time it takes effect. And as far as the effective date goes, I mean, well, we don't have absolute influence with the Board of Trustees. I would hope that if we told them that we want to either accelerate it or decelerate the effectiveness, to meet these needs, that they would accept that and go along with it.
And as a point of clarification, the first thing I note on the top is the transition period. An actual rule related to transition was pulled out of the rules, but only to be consistent with the practice in which the board determines the transition period. But I don't think it's intended to be like an on-off switch. The old rules were here, they are gone, the new rules are here, that there would be some element of a transition. And what I did on this page was just sort of break the rules up into their pieces, where they might give you an opportunity to divide up into pairs where you could look at the rules, the proposal, knowing that it may change, but looking with the fresh eyes of new members who have just joined, as well as the experienced eyes of the drafters who helped to put the proposal together, and start to think about, are these clear on their face, or is additional information needed? You did note in the drafting process that one area in particular where you would like some guidance is about advertising and communication, especially in a social media context. So guidance may be helpful there. But there were not actually too many other areas where specific guidance was requested during the drafting process.
Greg Murphy. Sorry, Paul.
I could just provide some comment about the ABA's experience with this sorts of things. The accreditation standards were black letter law, but then as the accreditation committee and the council dealt with issues that would arise because of changing circumstances or unanticipated things, that led to development of interpretations. And the interpretations then ultimately, some of them ultimately became black letter law. And that's kind of a natural process. It's not exactly the common law, but as the inspection and report process goes forward, and then even sanction processes where necessary. That's where the interpretations, or in the ABA, in our case, I think would be the guidelines, arose primarily out of that. I think it goes along with what Paul said earlier. The less is more is a good philosophy to have, particularly when we're seeing so much changing in education as a result of the you can call it progress, and some would say regression in light of the COVID. I personally think we're going to see some really interesting changes for the better in education as a result of COVID, which might be a nice outcome.
Thank you, Greg.
Yeah, so I would see transition period, what goes in the annual reports for the jointly accredited and non-jointly accredited schools, which I gather might be different. And the advertising guidance is the main areas we need to focus on. And maybe some more will come up, but certainly those.
And then Chair Gardina, I wonder if it makes sense, it is probably too soon to think about a deliverable, or the State Bar certainly has not proposed something specific for today, but to just take the time to possibly assign people to different areas so that they can be thinking about them. So that while everyone will certainly look over the proposal in general, you can have subject matter experts for the different areas.
I think that's a great idea, Natalie, and we can work offline in terms of dividing people up and asking them to take a look over what are now still draft rules, so we don't yet quite have the final look at what they're gonna look like in the end. So it's hard to start thinking about where ambiguities might exist, given that they might change in some way or form over the next 3 to 6 months. So I'm conscious of that as well, but I think certainly based on the draft rules, we can start to identify areas where we may need guidance from the CBE to either understand how the transition will occur or to understand how a particular rule might work. And I think the annual report obviously is on the table as well, but again, hard to do until we know what those final rules look like, and we can kind of backwards design that annual report based on what it is the State Bar needs to establish that we're meeting accreditation standards.
Exactly. And so I'd be happy to support you in that, particularly once the rules are posted any day, so that everyone can have access to the full and final proposal.
Great.
I have a question, and that is just to the extent there has been reaction from the CBE or even the Board of Trustees. Can that be shared? Was it generally positive, or was just we were going to withhold our comments until we hear from the public? I mean, what has been the initial reception?
I feel that at the CBE, although I would defer to Paul, that the reception has been positive. The Board of Trustees generally will reserve its point of view until things go out for public comment. It did deem it ready for public comment, but would probably reserve the discussion for when the rules return.
Yeah. Well, the fact that they deemed it ready for going out to public comment is a positive thing, it seems to me. So that's a positive sign.
I just wanted to ask a question, and I apologize up front if it's just me being relatively new. So the draft rules are going out for public comment for those 60 days. And I know that we have a designated place on the website with the State Bar where those would be filed. What other types of communications are going out to stakeholder groups that would make it clear to them about where that public comment is and what period of time to return those? I was just curious if there is a usual protocol with that, like email to the law schools or.
Once it's posted, it would make sense to do a general blast out to the law school deans, some of whom may be aware, some of whom may not, so that they can find that page and make those comments.
Mm-hmm. And I was just thinking, I know, I absolutely hear Dean Gardina on kind of the challenge of this group. One thing we could do, for example, if we do designate our priorities and topics, and I will leave it up to this group, but you can have, working groups or subcommittees, but it may be hard as things are flowing in the stream. Is there any possibility that, for example, if there's areas or points here where we definitely want the board to receive a written public comment from this group, that we could participate in that way? I'm just curious, because I think in my experience with the standards committee at DEAC, of course, that group itself is discussing so much, and it's not necessarily a publicly recorded meeting as such, as it's a private accreditation agency, but we open a lot to public comment. But that never blocks members of the standards committee, especially if they're discussing something about their specific institution, from submitting a public comment. Is that the same here?
Yes, so you would
Okay.
be speaking on behalf of yourself or your institution rather than CS BARS if you do your own comment, but
No.
your participation here does not prevent you from making a comment in that way.
That makes sense. Yeah, I just wanted to be sure. Thank you.
Mm-hmm.
And just to put it in the context of the work done, the CS BARS as a committee made a recommendation of a set of rules to the CBE. The CBE then took those and they made, along with some staff work, made their own recommendation to the Board of Trustees. And you'll see that the CS BARS recommendation and the pieces of where we differed were included in the package to the Board of Trustees. So I would say CS BARS made that recommendation already.
Oh, yes, thank
so
you.
individual members can certainly comment on areas where they feel it's important that the Board of Trustees, something be brought to the Board of Trustees' attention.
Oh, yes, thank you. I saw that from the meeting package in October. That comparison chart as well was very helpful. So great, thank you.
Mm-hmm. One thing that may also be helpful in the meantime is that when we were drafting the rules, I did actually reach out to Dean Park due to her work on the standards committee with DEAC to get some of their experience regarding communication rules. And it might be helpful for staff or potentially interested CS BARS members to do a little bit more of an updated literature review about what the guidelines are for various accreditors so that there can be some supple, clear guidance that is flexible based on the individual schools' communication plans.
That's great. We've done a similar review of benchmarks at DEAC that led to a revised guideline. So I would be very happy to, I could head a small working group here. I say working group or subcommittee, but sometimes it can be 2 or 3 people in a call, but I'm happy to do that and sort of volunteer so we have a strong foot forward on what to discuss.
I would, of course, defer to the chair.
Thank you, Jessica. And we'll talk about that offline, Natalie, and set up some groups and identify interest areas as well.
Mm-hmm.
Sounds great.
Okay. Okay, well, I think this sounds like a good foundation. Is there anything else that you would like to share on this topic today, Madam Chair?
Any other comments from the committee on this particular topic before we move forward? Okay. All right, thank you, Natalie.
Okay. And when you are ready, we can discuss topics for the Registrars and Law School Assembly meeting to the extent they have not been discussed through this meeting. Chair Gardina?
Yeah, so the question before us is are there topics that you would like to either be brought up, and Natalie, I believe you were gonna kind of invite more people to that registrars meeting beyond kind of just the registrars, is that correct?
Well, so the registrars meeting, those meetings are, they're not public meetings. A reason is merely to be able to have a large group that can have a very interactive discussion. For the registrars meeting, we suggested two individuals per school, as well as all of the members of CS BARS and the Law School Council also invited. So I'll do a separate call offline for anyone here. Some of you think you have already responded. If you're interested in participating in one or both of those meetings, because we will have folks that are specifically trained in a certain area, we can also get into a lot more detail in those meetings than we can here. For the law school assembly, we're suggesting approximately 3 members per school. And also, again, the law school council and the CS bars.
Great. Okay, thank you. And so the question that I think the State Bar staff would like answered is, what are some topics, certainly the things that we covered today, but maybe even more in depth on some of those that we didn't cover, questions that emerged, or other topics that you think it would be helpful to cover either at the registrars meeting or at the law school assembly. And I'm sure, Natalie, for those who are listening right now, you would welcome an email with any topics or thoughts that they had about things that they'd like to see covered in either of those meetings as well.
Absolutely. And normally, this is certainly a compressed timeline with these meetings coming up next week in order to be able to debrief from the online exams of the fall and get that feedback before the February bar exam. So if a topic is brought up today that's not realistic for next week, but could be considered at a future meeting, that would also be extremely helpful. So don't let the timeline constrain any suggestion. We will include all that we can, and we'll plan for the future as well.
Okay, great. So anything covered today or for a future meeting that you'd like to see at the registrars meeting or the law school assembly?
And we know that this year, this is a year where most people have been very concerned with the bar exam and the provisional licensing. So we understand that those will be the clear priority. We'll also be including information on an update from the Office of Access and Inclusion, further detail about the LAP program, further detail about the diversity and retention survey, and look forward to your additional questions.
So, oh, yes, Greg.
Well, I'm not sure, and I don't think it's for the registrars meeting, but maybe the other meeting you were discussing. And I've mentioned this before, the changes in the bar exam necessitated by COVID are likely to have some effects on the reliability of the examination. And you can't have a valid examination unless you have a reliability coefficient that meets or exceeds generally accepted psychometric standards. So, you know, I think that would be interesting to all, the California accredited schools and ABA accredited schools to see how what the data says about the recent administrations of the examination, because that has a real profound. It could have profound impacts on various communities that are of particular interest, and that should be watched very closely.
Thank you, Greg.
You might want to have a psychometrician to explain it in more detail. I could talk about it here, but I don't plan on attending those meetings. So, but that data is going to be critically important to the validity of the examination in whatever form it is.
Okay, thank you. Thank you, Greg. Other questions or thoughts from members of the committee?
Just I can't see everyone on the screen, so I apologize but I just want to echo, even thinking about what we covered today, at least for the law school assembly, Natalie, the topics that you mentioned would be front and center for the, just the minds of our deans and what we can relay to our students so they can take advantage of different resources or understand timeframes. And I think just besides the exam validity and the ways that is being proactively watched as we have changed logistics, I think I wouldn't necessarily go into as much detail, but I think maybe something that would reflect the work being done at the State Bar to communicate about the technology pieces of these exams in advance to the law schools. I know Audrey is doing that, but maybe just something to make sure that everyone is using that. And if there's a change in how that's coming out or about what issue, how that would be communicated, I think that would come up as pretty central. I think a lot of what got described here, especially, you know, that the bar exam strategies program is also going on. I think those are all great to note at the law school assembly. And for the registrars meeting, my experience of that is that often is helping equip that group with some of the tasks and some of the ways they need to access state bar resources or handle state bar forms that are sent out. So I imagine for PLL, that could be a helpful, more practical ground level covering of, you know, where do they go as students are asking them questions, and how to help ease the path so that things are directing the right way. I think that the fact that there's AIMS, which includes so many already tutorials instructions, helps greatly, but yeah.
And I think along that way, similarly, we received some recent feedback asking about a couple of things, and I wonder how you would feel about these. The first one related to e-transcript or e-signature. This is not something that the board uses that the State Bar uses right now, but understanding what schools are doing or what they might be thinking about doing in the future to receive that feedback from the schools. And then to provide to the schools visibility in two areas. One, showing what the portal looks like. Not every dean has seen that before, or potentially seeing if there is some sort of ExamSoft workspace that could be made available, but I'm not certain if that is possible. Would you have interest in discussing a little bit more about e-signature, e-transcript capabilities, as well as seeing the portal?
Absolutely. I think the e-signature, especially at these times, is very, very helpful, and could it could just help even with tracking of transactions if it's electronic versus other means.
Thank you, Jessica. I think for me, Natalie, two things came up based on what we were talking about that maybe more information would be helpful. So I know that I asked Amy about kind of what was the flagging that occurred during the bar exam, and did you have any data related to the number of flags and then what the ultimate outcome was? I know that you haven't yet completed that process for the bar exam, but I know that you did for the first year law students exam in June. I know it's an area of concern for students, just like, well, what if I sneeze? You know, what you guys received all the calls, what if my dog barks? I think explaining to the deans at the law school assembly, and probably the registrar, at least our registrar, has a lot of contact with students, especially around preparing for the bar exam, getting their transcripts out. What is that process? So you sneeze, or your dog barks, or your husband walks into the room, or whatever the case may be. What happens? It gets flagged, the AI flags it, then what, then what, then what? And then if you have first year law student exam from June data, it would be really interesting to see how many flags occurred, what filter happened, and then what were the numbers at the end of that filter in terms of actual disciplinary concerns or follow-up meetings. I think that would be very helpful for the deans and the registrars to hear that. So that's one area. The other one, and it may not be for this meeting, in part because you don't have enough time, in part because I don't think we have an answer, but if it turns out that the provisional licensing program is opened up to those who receive 1390, and if they complete a certain number of hours, I think both the ABA and every other law school in California will be interested in that. How does that recalculate our cumulative bar pass rate? And certainly, how does it recalculate the ABA bar pass rates in California? I think many schools will be very interested to find out how is that going to affect their data collection. How will the State Bar alert us to that? And what's the retroactive effect of a July 15 person passing the bar, but it's outside of the 5-year cumulative bar pass rate as a result. So just something for the state bar staff to be thinking of, and maybe it may not be an issue because it could be that that's never approved. But if it is, I think the law schools are going to be very curious about how that's going to affect bar pass rates.
Okay, thank you.
Yeah.
I did want to add very quickly to that. On the disciplinary side, I know that there are students that engaged in appeal to the disciplinary letters and messages that they have. And of course, I think on your side, what data is appropriate to be available in meeting, I'm not trying to discuss or dictate as to that, but I'm definitely curious about what that resolution process was. And I think at the value of it up front, like the takeaway, I think for me or someone in my position or in the dean's position, if there are ways we can inform students up front, you know, this is the picture of discipline you should expect with an online exam administrated by the state bar. These are the things you avoid, or, you know, it does trigger a hearing. It does trigger whether you have to turn down a hearing or not, or you're going to have to wait through the next baby bar attempt. I think I've heard a lot of questions about that from certain students. And I think just to remember for the law school assembly or the registrar's office, at the end of the day, I think it's just getting information so that if there's something earlier to intervene or to set the right expectation for that student, we want that too. It will give them an easier time when they go through. So.
Okay, well, I see that we are at the end of our time for this meeting, but I imagine, Natalie, if somebody comes up with another topic or idea or a more in-depth look at the topics that were identified today that you'd welcome, I'll speak for you, you'd welcome an email from somebody with those suggestions.
Of course, yes.
Okay. All right, great. So again, I appreciate everyone's time and attention. Jessica and Mike, it was great to have you be a part of the meeting. And I will entertain a motion to adjourn.
So moved.
All right. Okay. All right, everyone. It was wonderful to see you again.
Thank you,
Stay
Chair
healthy
Gardina.
and
Thank
safe
you.
over the holidays.
Oh,
Yes.
yeah.
Bye-bye.
Bye,
Thanks,
everyone.
everyone.
Goodbye.